Welcome, debtors and borrowers, to Bankruptcy Bailout, because debt ruins lives, not bankruptcy. Before we get started, please subscribe to this channel as a thank you for us providing this information to you, and like this video. Your subscriptions mean a lot to us and helps us to continue to bring this type of information about your financial situation, bankruptcy, student loans, and debt-related issues. So, my name is Matt Berkus. I'm a Colorado-based bankruptcy and student loan relief attorney. I've been doing this for about 20 years now. And today's question is about whether the economic injury disaster relief loans, these EIDL loans, are dischargeable in bankruptcy. So let me answer the question like this. The fact that it is an EIDL loan does not accept it from bankruptcy discharge. So in other words, the nature of the loan itself means that it can be discharged in bankruptcy. The loan has no special status or exception from bankruptcy. However, there are a series of catches to go along with that answer, as you might expect. So first off, what are these loans? I mean, these are these 30-year loans at around a 4% interest rate that people could get if they're in a disaster area. And these are basically related to all the COVID issues. And you could borrow, I think it's like upward of $2 million, but most people borrowed much less than that to help keep their businesses going. And if you borrowed $25,000 or less, the loan was unsecured. And if you borrowed more than $25,000, the loan is secured, usually against business assets. And I think if you went more than $200,000, the business owner may have had to put up their primary residence as collateral. That's not always required. Okay, so the first issue, or the first catch, is that these loans are typically secured loans. So you can't discharge the secured aspect of the loan, okay? But what we may be able to do, and this is a longer discussion, but I'll do the quick version here, is we can reduce the value of the loan to whatever the value of the collateral is. So if you have a $200,000 EIDL loan, but the underlying collateral is only worth $50,000, then a bankruptcy scenario, depending on your individual circumstances, might be able to reduce the balance down to $50,000, and you pay just that $50,000 and offload the other $150,000 in that $200,000 example. So the first catch, again, these are secured loans. Those get treated differently in bankruptcy. So you're not going to necessarily be able to discharge a loan and keep whatever pledged collateral you have against a loan. You're going to have to at least pay the value of that collateral. The other issues that we're going to face is, first, we're going to ask you, was the information you provided on the loan application accurate? Okay? Now, don't shoot the messenger and don't let this freak you out too much. But, there is an issue is if you misrepresented the financial situation of your business or made some mistakes, that can take this loan from being a dischargeable loan into a non-dischargeable loan. All right, so it's an issue of good faith there. So we want to be sure that in the loan application that the information you provided was more or less accurate. And then the other issue, and this may or may not be a big one for a lot of people, is how did you use the funds? Because you're supposed to use the funds for the business, so they have to be used on legitimate business expenses. If you didn't use the funds that way, all right, you're going to have a rough go of it in bankruptcy. All right. Now, that doesn't mean that bankruptcy is not an option for you. It just means you're going to need someone in there fighting for you, trying to negotiate this out and get the relief that you need. But, if you wholesale borrowed these EIDL funds and just use them on, your online gambling, unless you're a professional gambler, I guess, but you used online gambling, bought a car, you bought real estate and so forth, and didn't really use them in the business for which you got the loan for, yeah, that's going to be a problem. So, and then lastly, the fourth issue is just general reasonableness of the loan. Now, I don't think we're going to get much pushback on that because we are, dealing with, businesses that supposedly were struggling, and that's why they need this debt. So again, we're going to look at, what did you put on the loan application? How did you use the funds? Was it reasonable for you to expect to be able to pay back these funds? So I think for most people, you're going to be able to offload these EIDL loans in bankruptcy. And then we're just going to have to deal with what is pledged collateral or the security pledged for these loans and craft a solution around that. So that's what happens with these, or what we expect to happen with these EIDL loans in bankruptcy. So to recap, they are dischargeable in bankruptcy. There's no issue about that. They're not specifically accepted from discharge. However, they're mostly secured, so you can't offload the security interest in bankruptcy. And that's true of any secured debt. That's not just EIDL loans. Any secured debt, the security interest can't be offloaded in bankruptcy. You still have to address that differently and typically have to pay that. And then more specifically, we're going to want to be careful about what information was provided in the loan application. We're going to need an accounting of how you use the funds so we can evaluate what risks there are, risks of non-dischargeability there are going to be if you file bankruptcy on one of these EIDL loans. Because this is a major topic right now, because especially those people who got the second round of EIDL funding, you know, those loans, the payment notices are starting to go out, and I'm certainly seeing it in my practice. A lot of people calling saying, hey, I'm starting to get these payment notices. I can't make these payments. What can I do? Well, bankruptcy will certainly be one option to consider in addressing these loans. My name is Matt Berkus. I'm a Colorado-based bankruptcy and student loan relief attorney. If you reside in Colorado or have a business in Colorado, I can certainly help you with this. If you are a student loan borrower, I can help you nationwide. And I do charge a consultation fee for student loan borrowers. However, I do offer free phone consultations for the purposes of bankruptcy. Best of luck to you.